Hi, today on Off the Clock, we have a special treat. My colleague from our Detroit office, Josh Leadford, will be joining us. Did you know that even if you don't have a union in your organization, there are still things you have to be very, very careful of when disciplining and terminating employees? So this episode applies to everyone, especially if you have a union, but even if you don't. This is an episode to pay attention to.
Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
Are you excited to be on Off the Clock?
Absolutely.
First timer?
I'm first time, yes.
Long time listener.
Yes, absolutely.
I hope. So you are from our Detroit office, right?
I am. Recent lateral from a boutique labor and employment firm.
And how long have you been practicing?
A little over 13 years.
Always in employment and labor?
Always in labor and employment, employer defense specifically.
Okay, right. Only the good guys too, right?
That's right.
We only defend the good guys. That's what I tell all my friends and family. All right, and so some people actually aren't clear between the difference between employment and labor law. I'm more of an employment labor. I issue spot labor, and then I call you or Keith Eastland or Nate Planiga or one of the experts. So can you explain what the difference is between employment and then labor?
Sure. Well, that's one of the reasons I'm here, is because Miller Johnson has a very deep bench of traditional labor practitioners. So when I use the term labor law, you're referring to the National Labor Relations Act predominantly,
Okay.
which under the NLRA, it gives employees the right to join unions and unionize. And there is a public sector law, PARA, which allows public sector employees to unionize. Laws are very similar, but when I say labor law, it's the rights and obligations that come out of those laws specifically.
Got it. And that is, again, just to repeat, I'm going to be saying this a lot. This is for organizations that currently have unions and those that do not, right?
This conversation is probably more important for individual or employers that do not have unions because they're unaware of this specific issue.
Got it. So organizations with unions, this is probably already top of mind before they discipline.
It should be.
Yeah, it should be. Okay, so maybe even a nice little reminder
Yes.
For our organizations that do have unions. Okay, before we get to the real meat of it, right, terminating and disciplining without running afoul of the labor laws, can we take a very brief detour to talk about the rise in organizing that's happening right now in this country, but in particular in Michigan? Because whenever I talk to any client about labor and why we should care about the things we're going to talk about in a minute, I think everyone in this moment in time should be aware of what's happening, right? The ease with which employees can organize and then the success rate once they do try to organize.
So currently, the latest statistics I'm aware of indicate that union petitions for election have doubled since fiscal year 2021 for the National Labor Relations Board. Doubled.
Okay.
And between fiscal year 2023 and 2024, the increase was 35%.
Wow.
So there's been a drastic influx in union petitions for election.
Okay. Do we see that slowing down in the next few years?
I think that's doubtful.
Okay.
I think it'll continue to accelerate.
Okay. And are those petitions successful?
They are.
Largely? Okay. So what should employers look for to know if employees are starting to dip their toe in the water of organizing?
There's many signs of union organizing, and a key is to train your supervisors to spot those signs.
Got it.
Because one of the biggest problems for an employer that wants to, I don't want to use the word defend, but wants to be proactive in a union organization drive and ensure their employees understand what they're getting themselves into and the decision they're making. Supervisors need to spot those issues soon, because if the issue is not raised soon enough, you can lose the right to actually even have an election or the right to even educate your workforce. Currently on the books, and this could change, there is a process where a group of employees could unionize without an election. It could be basically an administrative filing, and there's inaction, and as a result of that inaction, you could receive a bargaining order, which means you are now a union employer.
But there may be supervisors may hear chit chat on the floor, right? There might be certain terminology used that's consistent, with union organizers,
absolutely.
et cetera.
Yeah, if your supervisor starts hearing the word grievance, If your supervisor all of a sudden is noticing more insubordinate behavior where employees are challenging decisions or orders given them. If you see groups of employees congregating together in ways that are different, all of those things can be signs of organizing. If you get to the most obvious signs of organizing, like a union organizer in the parking lot, or union authorization cards floating around, or pamphlets. Those are very late signs.
Okay.
Most likely the drive is well underway.
Okay, so every employer, public and private, should be aware that organizing is still upticking in popularity, and that they are more and more successful, and to look out for the signs, right, and symptoms, and call us or your favorite labor lawyer, right, when you notice anything, and even before, to train your supervisors.
To me, this is most certainly one of those situations where an ounce of prevention is worth a pound of cure. So working with your labor attorneys to do formalized training with your supervisors and managers, many of my client base have done that, and it's been very beneficial for them.
Okay, by the way, I completely agree, which is why I prompted those questions today. Whenever I talk to any labor lawyer about any topic, I want to make sure that employers are aware of that. So let's talk about a predominant issue that employers have to contend with, and that is collective and concerted action. That's a mouthful. And I always get tongue-tied when I say it. I don't even know if I said it right. But John, can you explain what that concept is? Please say it correctly too, and correct me if I'm wrong.
Absolutely.
And then what the concept is for folks that might be unfamiliar with it.
Yes. So under the National Labor Relations Act, there are bedrock rights of employees. Okay. One of those rights is to engage in concerted activities.
Okay.
And concerted activities can be undertaken by any employee, whether you are union or you're non-union.
Concerted activity.
Yes.
That's the key phrase.
Yes.
Okay, protected concerted activity.
And if we boil it down, it means an employee is undertaking activity meant to change working conditions. If you look in the treatise or you look in the case law, it might state to improve working conditions. I think the term improve might be used maybe overly favorably many times. Change is probably more accurate.
Right. It'd be hard to imagine a situation where employees would be intentionally trying to make working conditions worse, right? But worse or better is
depends
often
on the perspective.
In the eye of the beholder.
Yes. Yes.
Right? Exactly.
Yes.
So anytime an employee is trying to change working conditions, and working conditions can include wages, right? Hours of work, whether overtime is mandated, things like that. But what are other types of working conditions that might not be as obvious to folks?
Anything that ties to the workplace. And that's what's problematic for this discussion is the term concerted activity addresses issues one doesn't necessarily think would be a protected activity, even when you're used to dealing with union rights in the workplace. A traditional example of concerted activity is discussing wages.
Okay. Yep.
But it is much more broad than that. It can be so far as just complaining generally about something a supervisor's done and raising that issue, even though it's very informal and there's not a direct request to change something. Objecting to certain behaviors or certain actions that have been taken by supervision could be concerted activity. And there's a caveat for concerted activity. The activity needs to be on behalf of others. So 2 or more individuals. So there is a concept that's related to concerted activity called an employee gripe. So if an employee is taking action or making a complaint just on something that they have a personal stake in, it may or may not be concerted activity. So the key takeaway is this area of the law is very ambiguous, and what is concerted activity or not concerted activity can change depending on the administration that's interpreting the rules.
Right. I imagine that's very complicated in a lot of situations to figure out if someone's complaining. If they just say something is unfair, it may be very difficult to know whether they're talking about as applied to me or in general.
It's very fact intensive.
Right. But complaining about discipline I received and only I received arguably could be a gripe. Complaining about supervisor favoritism that favors first shift over second shift arguably could be concerted.
Well, yes, but except in the individual discipline standpoint, anytime the individual will allege that their activity was concerted, how the issue was raised is going to change, or it's going to be clarified. And it's not just that I was upset with the discipline that was issued to me. I'm challenging the fairness of the rule.
Right, which could be
on behalf of others.
On behalf of others.
So even something on the surface appears to be an individual issue can very easily expand to something that is concerted in nature.
Got it. So this is, when we say concerted activity, we're trying to drill down on what it actually is, because it is protected, right? And by protected, we mean we can't discipline or terminate employees for engaging in that behavior, right?
That's absolutely right.
Not even a step 1 or a step 2.
And even before that, you can't take action that might chill an employee from engaging in concerted activity.
Okay, so that's the one that really ties people up.
Yes. To violate the law,
with you.
Unlike most employment laws,
yeah,
you don't need to actually undertake an adverse employment action or implement an adverse employment action on the employee. Doing something that would chill the employee from engaging in the protected activity is an illegal act and would constitute what's called an unfair labor practice.
So we can't discipline or terminate someone for talking about wages, let's say, or complaining that wages are too low. But we also can't tell employees, you are not allowed to complain about wages being too low.
That's right.
Okay, got it. And would that also just include sharing wage information?
Yes.
Okay.
Under the law, traditional viewpoint, discussing wages is protected concerted activity. Now, there are caveats to that, and there are certain positions where you can prevent the individual from discussing wages, but that goes beyond, I think, this conversation.
Have you seen any conflicts between an employer's work rules? Because I imagine that's where a lot of, at least potentially, chilling language, as you said, that would chill an employee from engaging in the conduct in the first place. Have you seen any conflicts between work rules and the standard that the NLRB has established?
Yes.
What are the more common ones?
More common work rules that could be deemed problematic would be work rules requiring confidentiality of information.
Okay.
So,
all information. Boy, a lot of our listeners have confidentiality agreements.
So it depends on how the clause would be interpreted.
Okay.
And it will depend on which administration is enforcing the law and deciding which legal test will be proctored to the work rule in question.
Confidentiality of proprietary business information that is not generally known to third parties.
There you're probably safe.
Phew. Okay.
As long as the definition of proprietary business information doesn't include, for instance, wages. And sometimes when you go back to the document, wages are listed. But if it's traditional proprietary information, that might be, for instance, trademarked. Yeah. Yes, that is protectable.
Customer lists, pricing, those sorts of things.
Generally.
Business strategy.
Generally, yes.
Okay.
There's probably even caveats within some of those issues, depending on how the document is drafted. But generally, yes, those aren't going to run afoul.
Great. That is helpful. And when we're thinking about confidentiality agreements, because so many employers have them, they really only need to be particularly concerned with running afoul if we're talking about non-supervisors, correct?
That's right.
For their higher level executives and exempt salaried employees who are signing confidentiality agreements and maybe, non-competes or those sorts of things upon hire, our temperature is a little lower, right?
Absolutely.
Thinking about those.
And that's a really good point.
Okay.
Because only employees can engage in protected concerted activity.
Yeah.
Under the National Labor Relations Act, at least, supervisors and managers are not protected employees. So an employer can restrict similar activity if it's a supervisor or manager. Now, things are different for para. So if you're a public sector employer, supervisors can unionize under para. It'd be more confidential employees, which would be your higher executives within a political or a public institution, would not have the ability to organize.
Interesting. But for our private sector listeners, they really have to be concerned about what we're talking about for non-supervisory employees.
That's right.
Sometimes we might say hourly, but it's a little more complicated than that.
It is. A supervisor under the National Labor Relations Act has a specific definition. So it's somebody that actually has authority to, for instance, hire and fire or recommend that type of action. There's a multi-factor test that's implemented, and the term is actually defined under law.
Of course, because it has to be complicated.
Right.
So less concerned about confidentiality agreements are going to high-level employees upon hire, more concerned about confidentiality provisions in handbooks, for instance, that everyone employed has to sign.
Absolutely.
Is that fair?
That's completely accurate.
Okay, because I was concerned at the beginning of this, some of our listeners might be going back to those higher level confidentiality, non-disparagement, right, non-compete agreements and saying, whoa, not as concerned about your executives and high level folks. Okay, what are some other examples of work rules, let's say in handbooks, that could violate that NLRA because it could chill an employee's protected conduct?
Policies and provisions that require, I guess the good way to characterize them are civility rules. So rules that require good behavior, professionalism in the workplace.
Okay.
Rules that are worded like that could have a chilling effect on an individual employee engaging in protected Section 7 activity or concerted activities.
So this is going to make me crazy and everyone listening. So grab a cup of tea, take a deep breath. Are you saying that employees are protected from making complaints about workplace issues in an uncivil way, in an uncivil manner?
Yes. Yes. Yeah. The law does give employees some latitude in their demeanor and how they engage in concerted activity. And again, the test will vary depending on the administration and what legal theory is used to judge an employer's actions. In some cases and under some circumstances, you look at the employer's motives and you say, was the motivation to take action against concerted activity? Other times you look at a totality of circumstances where the question becomes, did the individual employee's actions rise to the level of culpability that they lose protection under the act? Did the employee act bad enough? Can be the fundamental question.
So you can cross a line.
Yes.
Okay. Where has the NLRB drawn that line in the past?
The current National Labor Relations Board General Counsel drafted a advice memo or a memo that explains some apparent conflict between the National Labor Relations Act and Title VII.
Oh, interesting.
So Title VII, of course, is the law that prevents general discrimination in the workplace.
Yeah, where could there be overlap between those two?
Well, if an individual, while they're engaging in protected concerted activity, makes a statement that could have a racial undertone, or makes a statement that could have that could be linked towards an allegation of sexual harassment, these activities can intersect. And the case law that's been rather longstanding would be on the picket line while a strike is underway. Individuals yelling at other workers that are crossing the picket line.
Yes.
That can get very heated, that can get very violent even. And then you look at what was said, does it rise to the level where it loses protection under the Act?
So if it does rise to the level of harassment under Title VII, does it lose protection under the NLRA?
Well, I think the way you ask that question, the answer would be yes. If it rises to the level of harassment under Title VII, does it lose protection? I think even under the General Counsel's most recent memo, the answer is yes.
Good. I like that answer, Josh. That's your favorite answer.
Yeah.
My favorite answer of yours today.
The problem comes up, though, that most employers investigating activities like this want to take action before somebody actually engages in harassment, actionable harassment under Title VII, severe and pervasive action that creates a hostile work environment. We don't want that to happen.
Of course.
So we want to take action earlier than that.
Right.
So then the question comes up, if you take action before the employee creates a workplace that is inconsistent with Title VII or actually prohibited by Title VII, did the employee lose protection of the Act?
This sounds like something people need help figuring out. Am I right?
You have to look at every single example.
Okay.
Every time you're dealing with this, it deserves, the analysis deserves to slow down and to ask these very specific questions. And even when attorneys are talking about these circumstances, there's not always a black and white answer. It's a very gray area of law.
Got it. So when someone is engaging in behavior that is complaining about the workplace, let's say, and also potentially harassment behavior, you have to look at that very, very carefully with an attorney and sort out whether you can do something about that or not.
You do. And a good common fact pattern there is a supervisor issues an order to work overtime or tells an employee you'll be working this Saturday. We all have seen the times where the employee reacts in an explosive manner.
Mm-hmm. Sure. Especially if they have a family commitment, etc.
Right.
Yes. So aside from harassment, Title VII issues, are there examples of where the NLRB has drawn a line and said, yes, you are complaining about workplace issues like overtime, etc., but the manner in which you expressed your disagreement went too far. It just crossed a line.
There are examples like that or legal theories like that where if an employee's actions cross the line over into disparagement of the employer or the employer's product.
Okay.
But again, the question is, did the action rise to the level of disparagement under the law?
Does that have to be disparagement to third parties or outsiders?
Could be disparagement to the employer's product, the employer itself. Action like that is so disloyal to the employer that it can lose its protection.
Got it. Okay. What about swearing?
Swearing would go back to a civility rule.
Okay.
And now that can become a question of the totality of the circumstances. Was it bad enough?
Okay. So it's not automatically.
And even if the test is motive or motivation of the employer, simply pointing to a work rule that prohibits swearing may not be enough because, again, the investigation might reveal that employees commonly swear in the workplace. I know people would be surprised, but there's been workplaces that I've worked at previously where
Josh?
where other employees swore, right? So if you're taking action against the individual that is engaging in concerted activity,
right,
but somebody else let an F-bomb fly and they're not disciplined,
and no one cares. Right.
There's a motivation issue. So you can still have a problem from an unfair labor practice charge alleging you violated an individual's right to engage in concerted activity.
We may have an issue at Miller Johnson. And the halls where labor and employment work. Just saying, it's the only time I've ever gotten in trouble at work, ever, was for swearing. Too much. Someone didn't like it, so I tried to clean it up. And I'm halfway there, 20 years later.
I've never used a curse word.
On air.
Right. Well, I don't know that that's accurate, actually.
There's this case that I hear my labor law colleagues talking about all the time, the Amazon decision. I think that's a great example. I don't know the ins and outs of it, but I think it's an example of a lot of what you're trying to make clear to me and the listeners. What is that case about? One
of the recent Amazon cases, I think the fact pattern is interesting for a couple reasons. One, there was an individual employee who engaged in concerted activity, brought complaints to management generally about workplace conditions. A couple examples might be the temperature of the warehouse. These were, warehouse employees that were stacking pallets for delivery and pulling packages for delivery.
20 pallets for the Strauss house in 1 week, probably.
For mine, 15, we're right there with you. So general complaints being raised by the employee, engaging in concerted activity. As part of all of this, at this particular warehouse, the individuals used carts to gather materials, and the carts were apparently defective. So at times, if a cart broke, you're supposed to wheel it off to the side and put a red tag on it or tag it as being defective.
Okay.
Well, not everybody did that. Sometimes they go off to the side. People still pulled them and used them because they needed to make their numbers and still, get the work out.
Yep.
This employee that was engaging the protected concerted activity had an issue with that, claiming that the use of some of these carts was causing injuries or harming individual employees. But things kind of go, in the case, one of the takeaways was an investigation for what this employee did to mark a cart as defective. Or maybe it was more than one, I don't remember. But off to the side the carts were, this person took a marker and wrote defective, I think, on the cart, but then also wrote the initials like ALU, Amazon Labor Union, OSHA, I think Teamsters, things like that. So there was an investigation that was undertaken.
Okay.
And this employee got a written warning or a written reprimand as a result of marking the property. So it was, under the work rule, it was basically damaging employer property.
Okay.
So, but through the investigation, the board ultimately concludes that the conduct didn't rise to the level to lose protection given the concerted nature and the concerns that were being raised by the employee.
Got it.
Also within this case, and this is, I think, a fact pattern that I see very often, the employer had work rules over I think the case calls it a whiteboard. So it's basically a online complaint forum so employees could raise issues with management and supervision. And some employees were going to the whiteboard to complain about management and to make statements and comments that were negative against certain supervisors and the like.
Naming certain supervisors?
Yes, and disparaging them, defaming them allegedly.
How did they feel about that, those supervisors?
That's what's kind of the takeaway from the case. The supervisors, I don't know, really did anything about it. It was other coworkers. Okay. It was the other employees that were upset that people are bashing these other supervisors unfairly. Mm-hmm. So think about those. This activity impacts the workplace, and it creates a negative atmosphere. Yep. Most employees don't want that. I think the vast majority of employees don't want that.
Agreed.
So employees actually went to the whiteboard and were complaining about the other employees making these type of comments and saying it's unfair, it's inappropriate, and it's prohibited by the work rules.
Okay. So employees complaining about employees.
Yes.
Okay.
So HR makes a statement that they will investigate, take action, and that type of commentary could be prohibited by their work rules.
Okay.
So the board in this case ultimately concludes that one of the work rules prohibiting the release of confidential information or defamation, disparagement, and like was overbroad because in that context where it was being used against complaints as to supervisors could be overbroad and chill employee activity and making those type of comments and criticisms of supervision on this online posting system.
So at the end of the day, the board decided that employees were allowed to complain about supervisors on that online posting system.
Yes.
So supervisors and apparently other employees need to chill a bit, right? I'm using chill in the exact opposite way you had used it. Need to understand that that is part of doing business is being criticized, right? Yeah. And we have to sometimes accept it.
Very often, in the case of the supervisor or the manager, very often one of your job duties and responsibilities is to turn the other cheek.
Yeah. Okay. So, and that is different than in years past where maybe employees would go complain at the corner bar, right, after the shift. And everyone does that from time to time. We all blow off steam every once in a while. But now in the world we live in, it's happening in places, online, social media, right, internally or externally, where everyone can see it. And it's extra embarrassing, frankly, and upsetting, often to supervisors and in some case coworkers, right, to see that kind of complaining.
And then on social media, like you see, whether it's these type of discussions or any other, the filter comes off. And people are more prepared to make these type of statements because they get to hide behind the screen.
And just to be clear, it doesn't matter. The example you gave at Amazon was an internal communication system. But would it have mattered if this was happening on Facebook?
Probably not.
Or LinkedIn? Okay.
Probably not.
So it doesn't matter that it was happening on an employer platform.
I don't want to go so far as to say in the analysis it doesn't matter what platform is used.
Yeah.
But generally, the advice I give is no. When I'm looking at a case, I don't really care if it's Facebook or an internal email. That's not, I think, going to really make that much of a difference, whether it's protected or not protected. I will say this, the fact that it's broadcast and more people see it standing alone is insufficient. I look at it as almost irrelevant.
Got it. Interesting. Since I have you here, a real live labor lawyer, and we've got a new Trump administration coming in, I think there's some uncertainty about whether the things we've just discussed are going to change a little bit. I think there's been a sense in the past few years under the Biden administration that lots of work rules and handbook policies, et cetera, were being viewed through a very broad filter as potentially chilling, right? Concerted activities. Do you see that changing in the next few years? Do you see it narrowing a little bit?
I think generally looking at a work rule in isolation and coming up with some theoretical interpretation that could chill somebody's activities, I think that changes.
Okay. Yeah.
To the benefit of the employer. Or I don't even want to say that. I think it goes back to a more pragmatic, realistic interpretation of the work rule. And not jumping to conclusions.
So we should not say you may never criticize the working conditions. We should still not say that.
We should still not say that.
Okay.
Yeah.
It should not be a work
the
rule.
fundamental rule
Okay.
does not change.
Right.
How it's interpreted and applied will change.
But civility rules, for instance, those are more, we can't promise outcomes, of course, but will more likely be viewed to be okay unless they are actually applied in a way to chill someone's protected right.
That's right.
That's how I'm
right.
thinking about it.
In any set of circumstances, and this is where a lot of supervisors get it wrong, especially in the non-union workplace, and I get into arguments about this, but our rule prevents or prohibits this.
Yeah,
And they did this, and it violates the rule.
right.
So I get to discipline. No. Just your rule cannot trump the law. Your rule cannot trump an individual's right to engage in concerted activity. So you cannot use the rule to impose the discipline. And that's exactly right. The rule in application still is problematic.
Got it. It's the we can focus now back to where we were a few years ago on the application and not on the wording itself, unless it blatantly prohibits protected conduct.
We should be able to once
It
once
takes
there's
a minute
it takes
to-
some time for the new
For the new
the
general
old
counsel.
to become new again.
Right. Yes, I agree, but it also takes a while for some of these complaints to wind their way through the system.
In fact, I think in our region, I was at a labor meeting last week.
Mm-hmm.
I think the average case to resolution is 222 days.
Oh, wow.
That's the number
Okay.
that's popping in mind. So it takes some time.
It does take some time. Okay, what are some takeaways, Josh? If folks could only remember, 3, 4, 5 things from this episode, what do you want them to know?
You train your employees about Title VII. You train your employees about sexual harassment, or you should. Most do. You should train your employees or your supervisors
Yeah.
about this concept of concerted activity.
Got it.
Because
Okay.
it comes up and it bites my clients. And some refresher training on this is really easy to do, and it pays dividends.
Yes. And that training would include, I'm assuming, once someone knows what is protected, we're not going to speak negatively about it, particularly in writing, but really at all.
The training is more than just what is concerted activity. It's what to do
Right.
about these type of things and how to protect yourself. Yes. And that's a really good point, because individuals don't know if it's concerted activity.
Right.
And it's fair to look into something to determine whether it is protected or not.
Mm-hmm.
Do you want that conversation taking place outside of privileged conversation with your attorney?
I would not.
The answer is, I agree. No.
Right, yes.
No.
If you talk about it with a lawyer, right, then it's all protected and can never be discovered by the NLRB or anyone else.
Right.
Right. So it's a time to pick up. That's one of those times I know you well enough, neither one of us counsel that clients should pick up the phone and call us for every single termination or discipline decision. That would not be a good use of a company's money. But when we're talking about disciplining or terminating because of something someone did or said about their working conditions, that's a good use.
That's
your
another
lawyers.
area where if the supervisors and managers are trained, they know to spot
Yes.
that as a potential
You have to
issue
spot it.
and slow down.
Yep.
Absolutely.
Spot it, call HR, and then HR can decide, which may include one of us.
It could.
Probably you. If they call me, I'm calling you. Thank you so much, Josh. This was great.
Absolutely. Thank you.